Morning. Happy New Year. Happy 2024. I'm just going to wait for you guys to come on in. This was a late one today. I know I usually come on at 10 o'clock, but I've been in meetings since I got in. As you know, I'm sure you know, like the first day back after a holiday is kind of bonkers, but I am here. Happy New Year to everyone. I'm glad to see you all alive and well. Comment in the box. Let me know where you're tuning in from. If this is your first time, definitely comment. Let me know it's your first time. I hope you all had an amazing, restful time during the holidays. I'm praying for favor and abundance and health and prosperity for all of you, watching, tuning in 2024. For those of you who had a tough time last year, I pray that this will be your year of breakthrough and, overcoming. If you're just embarking on your immigration journey or your case has been pending, I pray that this will be the year of yes, the year of your breakthrough, the year of your approval. I see a lot of first timers. Thank you guys so much for tuning in. Let me officially introduce myself. My name is Aisha Chidole, and I'm an immigration lawyer. I represent clients all over the United States with their immigration matters. We handle VAWA cases, T visas, U visas, marriage-based cases, naturalization, consular processing, fiancé visas, certain removal cases, cancellation of removal, SIJS, basically a lot of cases. So if you fall under any of that category or your friend or family member, definitely share this video or share our page so that they, can also learn as you learn. Today, I want to talk about getting a green card through domestic abuse. Okay. I've gotten a lot of questions recently about what is VAWA and, things like that. I'm going to focus more on VAWA today, but before I get into VAWA, I want to talk about other ways in which you can get a green card through domestic abuse. So you can get a green card, as with something called a U visa. If you were domestically abused by your partner or your spouse when they're not U.S. citizens or green card holders, or you were not, or they were, and you were never married to them, if you're willing to cooperate with law enforcement, right, in a U visa scenario, sometimes also with a T visa, if you can show, sex and domestic trafficking with your partner, let's say you were not married to the person or you were married to someone who wasn't a U.S. citizen, or a green card holder, that is also another way to get a green card. I mean, with a T and a U, what happens is you essentially get a visa first. You get a visa and, you have to have or hold on to the visa for like 3 years before you become eligible for naturalization, or with a T visa where you can do an early request if your case gets certified by, the certifying body. But today, I really want to focus more on Violence Against Women's Act, the law, just because with that one, you can file for your green card simultaneously and get your 10-year green card from the jump when you put in your application. And with that one, you don't necessarily have to involve law enforcement if you already have not or you're fearful of doing so. So the name says violence against women. That's what VAWA means. But VAWA is absolutely not for women alone. VAWA is also for men. VAWA is also for children. VAWA is also for parents. And let me explain these domestic relationships for spouses. So if you're a spouse of a U.S. citizen or a green card holder, and your spouse has been abusive to you, and you can show that at some point before or after marriage, you and that spouse lived together, and that the abuse took place in the United States, unless you're in the military and you're outside the country, the U.S. military outside, unless your spouse is the military outside the country, you can prove that you have good moral character, you can get a 10-year green card through that. Okay. The second category is if you are the child of a U.S. citizen or a green card holder, and you're under 21, you can do a simultaneous VAWA and green card application and prove the same thing, that your spouse was abusive or extremely cruel. No, your spouse, your parent was extremely cruel to you, and you get a 10-year green card that way. If you're between the ages of 21 and 24 and you never filed, but you just found out about it and you're like, oh my gosh, I'm eligible, right? In that instance, you can do what we call a late filing if we can show that one of the critical reasons of you not filing on time related to the abuse that you experience. Okay. The other category is for parents of U.S. citizens. So if you are the parent of a U.S. citizen and that U.S. citizen is over the age of the 21 and you can show that your child has been extremely cruel or abusive to you, you can qualify. With a lot of these, when I talk about, parents and, children, it can be a step parent as well or an adoptive. There are obviously different requirements for that. When you the easiest way to think about it is if, let's say you're a child and you're saying that, you were abused. Let's say you're doing it like after the age of 21, you want to show that, not after the age of 21, after the age of like 18%, for example, like you want to show that you as a self-filer, that you were, your parents, a parent and the step parent were married before you turned the age 18. Okay. So there are more nuances into the different categories, of children versus parents and age. But, I can talk more about each of them individually in like different sessions. But the general idea is that, there are different ways in which if you've been a victim of domestic violence or domestic abuse, you're able to get your 10-year green card that way. And a lot of times when you are married to a U.S. citizen and you get approved for your 10-year green card and your U.S. citizen at your 3-year mark has been a U.S. citizen for more than 3 years, you can file for citizenship and get your citizenship. So there are many advantages that come with doing a VAWA self-petition. Unlike the others, like a TOU visa, you can get a simultaneous green card. Hey, Aju, I'm so happy to see you on live today. I was just thinking about you a few hours ago, actually. Anyway, so as I was saying, one of the advantages is that you can get your 5-year work permit and your 5-year travel permit at the same time, while your case is pending. Like you don't have to wait until your case is approved. So from a time, unless, you're married to an LPR, like a green card holder and there's no visa available, but so you can get that, instead of waiting, 3 years, 4 years, 5 years to get even that, you can also get something that we call a prima facie determination letter. With a prima facie determination letter, for a lot of people, depending on what state you live in, it will allow you to get a driver's license while you're waiting on your work permit. Because, some states you have to basically get your work permits before you can get a driver's license, but other states you can get a driver's license, for example. Yes, yay. For example, Texas is one example where you have to get you can get your driver's license with just a prima facie. Also, in some states, it will allow you to get public assistance or housing assistance. Some states will have requirements though where you can't live with the person that is doing that to you in order for you to get assistance. And then in some other regards, it's you have to I'm trying to think what are the requirements for the prima facie. In some regards, also, you might be able to get financial aid. A lot of this is very state dependent and school dependent. Like, so if you wanted to go back to school, these are all some of the things that you can do. But for a lot of people who are victims of domestic violence, there's a lot of fear in basically reporting what is happening and knowing what options are available for them, because a lot of them deal with a lot of psychological abuse where they've basically told you that, if you report this, you're basically they're going to deal with you. You're going to get deported. You're the one that's going to get arrested. One thing to note is that USCIS officers are prohibited from contacting or talking to your abuser or disclosing that information to them to protect you. So this is something that at least will give you reprieve in knowing that you can do that. And also, you are permitted to have a safe address. If you live with your abuser, you are permitted to have a safe address where you can send your mail so that they don't know what's going on. For instance, at our firm, we have our address as a safe address, so all our clients' mails are sent here. And then usually we'll ask our client, where is a safe place for us to send it to. And for some people, if they live with them, they may do it like in a post office box, or they will send it to like a friend's house. Basically, whatever it takes to keep our clients safe and confident is, what our goal is. So yeah, these are some ways in which you can get your green card through domestic abuse, so TU and VAWA. I see so many comments. Let me just try and get to them. I'll get to as many as I can. Let's see what we've got here on Instagram. Trenton, New Jersey, checking in. Good morning. How long does T visa process take? Honestly, it really depends. It could take anywhere from 18 months to 30 months. It just really depends. Omid, you're very welcome. Happy New Year. First time out, allow me, and young 90s. Good morning. AJ Braids, good morning. Good morning. First timers, so many of you. Good morning. Thank you so much for tuning in. How many times and how long can I travel in a year with a 10-year green card? You can travel as many times as you want. The biggest key is that if you're traveling, you don't want to be out of the country for more than 6 months, right? And also you want to be mindful, if you do plan to naturalize when you become eligible, what they're usually looking at is that half of that time of eligibility you've been in the United States. So let's say you're doing it because you and your spouse you're applying for naturalization because you and your spouse have been married for 3 years. You want to show that at least 1.5 years of that was spent here in the US. If it's based on a 5-year mark because, you're not doing it with your spouse, for whatever reason, it doesn't matter. But if you're doing a 5-year, they want to see 2.5 years that you spend the time here. So use that as your gauge. One, you don't want to travel for more than 6 months, at a time, so you don't run into any issues of abandonment or having to get a reentry. You certainly don't want to do a year without applying for a reentry visa. And making sure that if you do plan to naturalize, that you meet the time requirement to naturalize. Okay. Trump says, I filed for spousal abuse. My kids are in Jamaica. I filed for a valid case based on spousal abuse. My kids are in Jamaica. If I let them come to the U.S. and overstay on a visiting visa, will they get an EAD card since they'll now be in the U.S.? It doesn't quite work like that. If your children end up in the United States and they end up overstaying, or not necessarily even overstaying, but you choose at some point to do an adjustment of status for them, you can do an adjustment as long as they're under 21. Okay, so you said they're 18 and 20. You can do the adjustment of status, and then when you do the adjustment of status application, that is when they would be able to get the EAD. But you can't just arbitrarily file an EAD for them based on your VAWA application. You have to actually file an adjustment of status that is based on your I-360 that is pending. All right. Okay. I see a lot of Happy New Year wishes, and same to you guys. What if your spouse is threatening to withdraw your I-130 to get you deported because you confronted him about cheating? Nails by Momo, that is definitely a red flag that you might be in an abusive marriage. Infidelity on its own is not necessarily a form of abuse or extreme cruelty unless you can show a pattern of behavior that has arisen to the level of extreme cruelty based on the infidelity and how that affects you psychologically or physically. Some people, they have spouses who are so unfaithful, people sleeping around, no protection. And this could be man or woman, and then coming back and giving their spouse an STI, an STD, and how that affects them. So there are many things that we can certainly screen you and ask questions about to see if you will be eligible for that. But don't let the fear of your spouse threatening to redraw an I-130 because you're calling the person out on their unfaithfulness be what makes you worried, if you qualify. Because even if he withdraws his I-130, if you're eligible for a VAWA self-petition, then you can do that whether the I-130 exists or not. Okay. My permit was approved. I didn't get it. It went to the wrong address. Well, sorry about that. If it went to the wrong address and you're sure it was delivered to the wrong address, you're going to have to, I don't know what kind of case you had. If it's just a regular marriage-based case, you can either reach out to USCIS, either online or via phone, and let them know your change of address, or that this was not the correct address and it went to this address. Sometimes USCIS, out of the benevolence of their heart, will send you a new one. Sometimes you may need to pay for it if USCIS says, well, we never got it back, because sometimes they want to get it back before they send it to you for free. But immediately you get off this live, just go and do that, okay? Liz says, if the VAWA was filed along with the I-485, as soon as the I-360 gets approved, does that mean that both of them were approved? No, it just means that the I-360 was approved. So typically what happens is that once your I-360 is approved, give or take, it can take anywhere from like 1 month to 6 months for your 485 to be approved. What typically happens is that they will either send a request for your medicals, like your medical exams, or depending on when you filed, if the I-864's waivers were not submitted, then they will ask you to submit one, or they'll schedule you for an interview. These interviews are really to go through your I-485 form to make sure that there's nothing in the form that would make you ineligible for a green card. So it's a two-step process, but honestly, the biggest hump is getting that VAWA approval, because there are more odds in your favor that you'll get the 10-year green card once you get the VAWA approved, because it's really more of a simpler interview. They're not questioning your marriage or relationship, and they're not questioning the abuse. It's just making sure you don't have any crimes of moral turpitude. You're not in deportation that you've not terminated. You're not in, you didn't go and remarry while your case was still pending. That's one thing to note. If you do file a VAWA application, you cannot marry while the VAWA case is pending. If not, you won't get the green card, or they can revoke the green card if they find out. Okay. Good morning. This person says, I was verbally, emotionally abused. My husband is controlling. He humiliated me, gaslights. I had to call the police on him. He served me eviction notice a few days after. Well, Lexi Kai, I'm very sorry to hear this. I'm happy to have a confidential consultation with you. You can schedule a call, 407-995-6567. And then we're happy to screen you just to see if you would qualify for a VAWA self-petition. And that would be your best route. If your husband is not a U.S. citizen, or a green card holder, then we can screen you and see if you'll be eligible for a U visa or a T visa. Okay. Can you do me a favor, please? How can I get a visa to your country to study a master's degree? The best way to do that is to actually get into a school and then apply for a student visa. You want to make sure that you get into an SEVIS school. Those are the schools that will allow you to get an F1 visa to come here and study. Okay. Milton on YouTube says, USCIS received my VAWA case in September of 2021. I received a prima facie work permit, advanced parole in 2022. I have no news since then. Is this normal? Yes, it's normal. It's normal, but let me see for sure, because I don't know your case. I don't know if you have an RFU and NOID coming, but you should, if there's nothing wrong with your case, this year you should definitely hear something of some sort, either an approval, a request for additional evidence, a notice of intent to deny, but you should hear something, hopefully this year, knock on wood. David says, so your spouse can stop your VAWA case if she finds out that you're doing that? Your spouse cannot. Let me repeat that. Your spouse cannot stop your VAWA case, okay? USCIS, first of all, like I mentioned, has to keep your case confidential. if USCIS receives word or something, like we've certainly had abusive spouses lie on their spouses or tell USCIS something, the rules basically say that USCIS cannot make a negative decision or deny a case based solely on anything or any negative thing that an abuser tells USCIS or an abuser's parent who may have lived in the household tells USCIS. They have to look at the totality of your own application of evidence. But USCIS is not allowed to disclose or even acknowledge to anyone that you have a VAWA application pending, because if so, many victims will not be able to put the application up because of the fear of retaliation. Okay. Andrew says, my VAWA was approved last month. Today I got the updates, 485. They asked, I'm not sure what you're asking me, honestly. Like, what kind of update did you get? Did you get a request for something? Is that what you're saying? If you can just be a bit more specific, I'll be able to answer that. Linux, if you need to schedule a consult, you can, 407-995-6567. You can also send a WhatsApp to 404-333-8751, okay? Sosa says, my U visa has been pending for 5 years. I now just got a work authorization. Well, congrats on getting a work authorization. Yes, U visas take a really long time. So when we can screen a client and determine that they're eligible for a T or a VAWA, it's a preferred route than the U visas. I mean, if that's your only route, it's your only route. But, they tend to take much longer than all the others. Nomad says, does the abuser have to be a U.S. American citizen? Not if you're submitting any of this category. So with VAWA, the abuser has to be a U.S. citizen or a green card holder. Okay. With a T visa, the abuser does not have to be a U.S. citizen or a green card holder, or you don't have to be married to the abuser if they are U.S. citizens or green card holder. Same applies with the U visa. The U visa, though, you have to be willing to cooperate with law enforcement because they have to certify that you've cooperated with them. With the VAWA cases, if you file a police report or if there's a police incident report, we certainly love that and we certainly want to send that, but it is not a requirement. And we get many, many, many cases approved without a police report, as long as we have other credible evidence to show that what you're saying is truly what happened. How long does VAWA-based green card take as of 2024? Well, since 2024 was yesterday, I need more time to let you know. You said it's been 3 months since you filed and you're waiting after receipts and fingerprints, which they used for my prior case. What comes first, prima facie EAD? Honestly, they're kind of separate. Like the prima facie and EAD are kind of separate because the prima facie comes whether or not you submit an EAD application through adjustment of status or not. So can't really say, but most people will get the prima facie first, but it's not necessarily guaranteed that you would get it first, because it all depends on what's going on with your case. A normal timeline can be anywhere from 2 years to 2.5 years for the VAWA decision to come forth. I'm a U.S. citizen. I would like to apply for a fiancé visa for my husband-to-be. How do I go about applying for a fiancé visa? First and foremost, Jada, call us. We'll help you with that. But we definitely have requirements for a K-1 fiancé visa that we need to show. We got to show, one, that you meet the proof of having seen each other at least once in the last 2 years, you meet the income requirement, and that you'll be able to marry that person within 90 days of being here, but we'll be happy to help you. This person, Amadia, says, can you introduce a good person who can marry me so I can get a visa? We're not a dating service. We're an immigration law firm. We do not do any kind of matchmaking or matchmake people, but good luck to you in finding the love of your life. If you apply for VAWA and you got an update that you received a 48-month extension and your green card is about to expire, how long does it take for you to receive that copy? I guess the question you're asking is that if you applied for a removal of conditions on your green card based on extreme cruelty, which is different from what I'm talking about. But if you do that, basically you would count 48 months from the expiration date. So that extension letter, let's say your stuff is expiring in 2024, that green card extension will be up till 2028. It doesn't mean it's going to take them up till 2028 to make a decision on your case. It just means that you have that just so that if you get approved before that, great. If you don't get approved, you have something so they're not, going back and forth with immigration, basically. LeBron, thank you so much. I really appreciate it. Stylist, how can I get a consultation with you? I don't have it offhand what my earliest appointment is, but please call the office 407-995-6567 and schedule a consultation either with myself or any of my trusted associate attorneys who are just as excellent as I am. We work together as a team at my firm. Every single case, whether or not I consulted with you, will go through me. I will work on every single case, okay? Does this apply if the abuser's parent is a citizen? No. So VAWA, you can do it based on your parent-in-law being the U.S. citizen. It has to be the abuser's spouse. However, if you're being abused, well, he said the abuser. So we look at, so if you're not eligible for VAWA because the abuser is not a U.S. citizen, then you want to look and see if you may qualify for a T visa or U visa. One question, can a citizen bring his brother with a green card? You can apply for your sibling. It's just that sibling petitions are the longest applications. So sibling petitions take anywhere from 16 to 20 years. It takes a really long time. It's doable. It's just, it takes a really long time. And the wait is best outside the country because, if you overstay, then you have to basically go back, do a 601 and go back. Okay. I'm in an abusive relationship and I applied for adjustment of status and got a combination card. Now, should I file for VAWA or adjust and wait another 6 months? Sumnam, I would love to screen you to see what is going on and see where exactly your case is. It's really hard, to be able to answer those types of questions in a live without really knowing the full story. So consult with me and then we'll see. Again, 407-995-6567. Pav says, if you prove abuse, does the parent get charged? No, the parent doesn't get charged. Remember what I mentioned earlier, USCIS is not permitted to disclose to an abuser what you've petitioned for or what happens. And I know that because imagine if they had to do that, how fearful a lot of people would be or stay in these situations that are dangerous and life-threatening for many because they don't have anyone on their side. In order for victims to come forward, they have to know that they can trust, the government or the system to work in their favor. So no, they will not get charged. Valencia says, is this the same for all states? I'm not sure what this question is related to, but all these case types I have referred to apply to the entire United States of America. Work permit for VAWA timeline. Timeline is dependent on if you submitted an adjustment of status application. So if you submitted an adjustment of status application and added a work permit based on that adjustment of status, then a timeline that's realistic would be anywhere from 4 to 9 months. We're definitely seeing a lot of 4.5 to 6.5 months. So that's good. And I hope that that trend kind of continues into this new year or even earlier. If you didn't and your work permit is based on an approved VAWA, then timeline-wise, you're looking at 2 years to 2.5 years. So if that would be where you would fall. Hey, Ashadi, Happy New Year. My wife is under DACA. She's thinking about doing advanced parole. She's from Nigeria but needs to go to Canada. Her mother is there. Would she be able to go? The 444 Wolfman will definitely have to talk about what the reason or the need for the visit. The visit has to be extenuating. So if she's able to show that and apply for advanced parole and get approved, then she certainly can go. And then if you're a U.S. citizen and she's DACA because of how she entered into the country and she's not able to adjust, if she gets the advanced parole and she's able to go out and then come back in, then you can actually then do her adjustment of status. But we'll need a little bit more details to understand, her immigration history. Okay. Emmanuel Dowie says, can I file for VAWA after my I-485 is withdrawn? The answer will depend on your current marital status and where your case is, but it's certainly an option. But definitely schedule a consult and then we can see and make sure that you're good to go. Do you take cases in the state of Florida? Of course, we've got an office in Florida. We take cases in every single state in the United States, but Florida is definitely a special place. That's where my practice started, and that's where we've got an office, as well as here in Atlanta, Georgia. So we always take cases from Florida and every single state in the United States. Your state is not an obstacle at all. I put in my paperwork in August. I haven't heard back. Should I be worried? Ms. Barry, I don't know what paperwork you put in. So I can't really answer because I'm not really sure what you put in. And when you say you've not heard anything back, do you mean you've not received like even a receipt notice confirming that he got it, like they've not cashed your check or any of all that? Let me know. I'm an H-2B worker and I'd like for my daughter to visit me when she gets on holiday. How is that possible? She's going to have to apply for what we call a tourist visa. It's a B1/B2 visa, which will allow her to come and visit. All right, I'm going to take 2 more questions and I got to jump off. But I am going to be live tomorrow again at 10 a.m. Eastern time. So if I didn't get to your question today, definitely tune in live. I will be live at 10 a.m. tomorrow. Okay, someone said, if is permanent I-485, if the permanent I-485 is approved before divorce hearing valid, wait, let me understand. So I'm not sure if I understand what you're asking me. Did you get divorced and before the green card was approved? Is that what you're saying? If you got divorced before the green card was approved, they may take that from me at naturalization stage. So, that could potentially be a problem. But I'm not sure if that's what you're asking. Okay, this is the last question I'm going to take. If you applied for adjustment of status after you got married, can you travel outside the USA? Only if you get an approved advanced parole and you travel within the timeline required there and you don't have any deportation issues. There are no issues with your case and stuff like that. Okay. All right, guys. I enjoyed chatting with you guys this morning. Tune in tomorrow at 10 a.m. EST, Eastern Standard Time. And you can ask the rest of your questions for those of you who I didn't get to. All right. I'll talk to you guys tomorrow. Bye.